It's only day 12 of the Trump administration. He's already 0 for 3 in federal courts with a new temporary restraining order issued against his attempt to freeze U.S. government spending and funding at the state level and for all of its programs, sending the economy into chaos and Americans into shock that's now been blocked by Chief Judge John McConnell in Rhode Island, joining Judge Ali Khan in the District of Columbia, who also ruled that the freeze should not go into effect. What I found interesting about Judge McConnell's decision is that he doesn't believe a word that Donald Trump's people say. And when the press secretary, Carolyn Levitt, stares at the camera and says, and there's a press release that says, we're going to lift the actual, we're not going to do the freeze. We're not going to do the impoundment of funds, which is unconstitutional, which was a very cynical attempt to try to divest this court, this federal court in Rhode Island and District of Columbia, from jurisdiction. They were called out by John McConnell. He said he doesn't believe a word the press secretary has to say. I'm Michael Popak. You're on Legal AF on the YouTube channel, and let's dive in. It's been a busy week for Donald Trump. He must want to just tie his administration up in knots. I mean, there's reporting that he's gone so far that even his closest advisors and supporters are shocked, and not in a good way, by how out of control Donald Trump has been. All right? Federal courts aren't shocked. The lawyers, like the attorneys general who have filed these various lawsuits, are not shocked. I mean, by my count, we've already got 10 different lawsuits being filed in 5 different jurisdictions, resulting in 3 temporary restraining orders. Let's dive in on John McConnell, and I'll read to you from his order and the aspects where you know he doesn't trust the Trump administration. See, here's what happens with the temporary restraining order. Having practiced federal law and injunctions and restraining order law for a long time, you have to go into court as the plaintiff, as the movant, and you have to prove 4 elements. A little bit of a legal AF breakout session here, like a law school class meets a TED Talk. 1, you have to show irreparable harm, meaning the harm is of such a nature that it can't be compensated for by sheer money. Like if you destroy the Meals on Wheels program for senior citizens because you're not funding it, and you kill senior citizens as a result, no amount of money is going to solve that. That's irreparable harm. Likelihood of success on the merits is what it sounds like. We're early in the stage of the litigation, but the judge has determined, peeking under the hood here, that you're going to win at the end of the case based on the evidence he's heard so far. It's likely that you're going to be the winner. Then the judge looks at the balance of equities. There's a lot of scales and balances in the courtroom, and one of them is the balance of equities. Has to tip in your favor. And then the injunction and issuing the restraining order, a type of injunction, has to be in the public interest. And on all 4 factors, you have to get all 4. The judge here, Judge McConnell, found for the attorneys general and others in the states that brought this particular action against Donald Trump. And he particularly focused on, he thinks it's a likelihood of success in the merits, that Donald Trump's attempts to freeze congressional funding is a violation of the Administrative Procedures Act and a violation of delegation of authority, because Congress did not delegate to the executive branch the authority to do this. If you cross that line, you're violating separations of power under the Constitution as well. Judge also found that it was arbitrary and capricious, violated the separation of powers, and violated other aspects of the Constitution, including the spending clause. Having gotten there, he quickly determined that it was irreparable harm, and that it would the balance of equities, of course, sided with the states trying to preserve the status quo, which is the period right before the attempted freeze. Then the judge turned to the cynical attempt by the Trump administration to rescind the block on the freeze, right? Oh, we were only kidding. We're gonna the temporary freeze. Oh, we were only kidding. We're taking that back. The judge said, not so fast. That looks like, to everybody, you're trying to divest the court of jurisdiction, because the way it works is there has to be a live controversy. And in an injunction setting, you have to have continuing harm in the future in order to stay it or enjoin it. no matter how bad the acts are that form the basis of a lawsuit, you're not going to get an injunction about that act unless there's a real possibility of it happening in the future. If you just come into court and talk about really bad things that have already happened and happened in the past, the judge will say, well, that's great, but you'll get money damages for that. To seek an injunction, like a temporary restraining order, you have to show that it's an ongoing harm, and that the judge has to stop it now, or it will happen again. Stop me before I commit another crime, something like that. They tried to avoid that, but they were too smart by half in the Trump administration and their Department of Justice. So they decided, try to rescind it. Then there won't be a live controversy and he won't be able to issue an injunction. Now remember, Judge Ali Khan down in the D.C. dealing with the exact same issues, but for different parties, already blocked it until February 3rd to give her time to get full evaluation and briefing. And just as a side note, Judge Ali Khan was appointed by Biden. Judge McConnell was appointed by Obama. To the extent that that matters, I'm going to talk about strategy in a minute and why these cases were filed against Donald Trump in the jurisdictions that they were, the federal courts that they were. So McConnell took it on head on. Actually, let me read to you from the decision and the key points. Yeah. This is a temporary restraining order entered, actually today, it's 13 pages, went through the likelihood of success on the merits and found that the states had proved that based on the evidence before it, the states are likely to succeed on the merits of some, if not all, of their claims as follows. The executive actions is on page 5. The executive's actions, the president's actions, unilaterally suspends the payment of federal funds to the states and others simply by choosing to do so, no matter the authorizing or appropriate statute, the regulatory regime, or the grant itself. The president cites no legal authority allowing it to do so. Indeed, no federal law would authorize him to do so. Then he goes on to say, the judge says, Congress has instructed the president to provide funding to states based on stated statutory factors. In other words, he's the executive that's supposed to implement the will of Congress. By trying to impose certain conditions on this funding, the executive has acted contrary to the law and in violation of the Administrative Procedures Act. And by giving states less than 24 hours, he found that the pause was arbitrary. This is the judge. Congress has not given, according to the judge, the president limitless power to broadly and indefinitely pause all funds that it expressly directed to specific recipients and purposes, and therefore the executive actions violate the separation of powers. The judge goes on. That's on likelihood of success on the merits. On irreparable harm, he goes through all the ways cutting off federal funding at the last minute will jeopardize important vital programs and services that will harm Americans. All the states, on page 7 of his order, he says, all states rely on federal funds to provide and maintain vital programs, and withholding those funds will cause a severe disruption. And then he gave examples. These programs that the executive branch has cut off funding from include highway planning and construction, child care, veteran nursing care funding, special education grants, and state health departments, who receive billions with a B of dollars to run these programs, to run a functional healthcare system. He then went on to talk about that pausing this money also pauses current disaster relief efforts, like in North Carolina, in Florida, and in California. He also said that it also impacts severely drug case trafficking. That will impact the public safety because it will cut off money to that funding. He went through the balance of equities and the public interest siding with the states. And then we get to mootness. And that's the point where I'm telling you the judge is basically saying, and I'll read it to you out loud, that he can't trust the Trump administration at all, nor the press secretary. Here you go. By the way, welcome Carolyn Levitt, youngest press secretary ever. You went out of the frying pan into the fire. You caused the collapse and the crash of the Medicare Medicaid portal because of the way you handled one press conference. And here a judge is calling you a liar. The defendants now claim, this is on page 10, the defendants now claim that this matter is moot because it rescinded the OMB directive. In other words, they're saying, Judge, well, I don't know what you're talking about. We got rid of that freeze. Messaging from the White House and agencies proves the point that the substantive effect of the directive carries on. Messages from the White House and agencies prove that point, the judge says. at 2:04 Eastern Time, less than an hour before the court's hearing on the state's motion on Wednesday, the defendants filed a notice saying OMB elected to rescind that challenge memorandum, which is the freeze. Yet about 20 minutes before the defendants filed the notice, the president's press secretary, that's Carolyn Levitt, sent a statement via X saying the president's executive orders on federal funding remain in full force and effect and will be rigorously implemented. So the judge is saying, well, which is it? The press secretary says the block of the funds is on, and you're telling me the block of the funds is not on. I'm going to somebody's lying, or you're both lying. He also pointed to the Environmental Protection Agency sending out an email to federal grant recipients telling them that the awarded money that they thought they were getting would not be dispersed while they're waiting around to work out the temporary pause. As the judge said on the end of page 11, based on the press secretary's unequivocal statement in the X and the continued actions of the executive agencies, the court finds that the policies in the OMB directive that the state's challenge here are still in force and effect, and thus the issues presented in the state's motion are not moot. In other words, good try trying to cut my jurisdiction off. I caught you. Here's the conclusion. In other words, the restraining part of the order. The court hereby orders that a temporary restraining order is entered in this case until the court rules on the state's forthcoming motion for preliminary injunction. Here's another breakout law school class. You get a temporary restraining order first on kind of a more minimal record and briefing, and you're going into the judge within days after filing. This was within a week of filing. Then the judge sets a briefing schedule for what's called a preliminary injunction, which is a more fulsome injunction that stays in place throughout the course of the case until you get to a full trial. TRO, then you have a separate proceeding, briefing, hearing, evidence on preliminary injunction. Let me tell you that in my 35 years, having gotten a TRO, I've never not gotten the preliminary injunction. You almost always get the preliminary injunction after the TRO, but the judge is going to keep the TRO in place until the preliminary injunction, or what we call the PI, is considered at a later time. During the pendency of this TRO, the defendant shall not pause, freeze, impede, block, cancel, or terminate defendant's compliance with awards and obligations to provide federal finance assistance to the states, and shall not impede the state's access to such awards and obligations except on the basis of applicable statutes, regulations, and terms. He goes on to say, if defendants engage in the identification and review of federal financial assistance programs, such exercise shall not affect a pause, freeze, impediment, block, or cancellation. In other words, they can evaluate, they just can't freeze. They have to give written notice of this order to all defendants and their agencies by Monday at 9 a.m. That's the same day that Judge Ali Khan in the District of Columbia is going to be having a full hearing about her temporary block. See, multiple courts can block. The TRO shall be in effect until further notice of the court. Signed, Chief Judge, United States District Court of Rhode Island, January 31st, 2025. Now, let me get back to why we're in these courts. Let me tell you the courts we're in, just so you can keep track. This is between the Birthright Citizenship TRO that was entered by Judge Coffenor in Seattle, Washington. We're in the following courts with Donald Trump right now. Think of what's the common denominator? New Hampshire, Massachusetts, Rhode Island, DC, Oregon, and Washington. What's the common denominator? You can put it in comments right now. These are moderate to liberal federal districts where it's more likely than not you're going to get a Clinton, an Obama, a Biden appointee. There might even be a Carter appointee floating around, as opposed to the Fifth Circuit, the Texas, Louisiana, even places like Missouri, in other jurisdictions, Florida, where it's 50-50 or less. More importantly, or as importantly, these trial courts report up to appellate courts that are also liberal to moderate. For New Hampshire, Massachusetts, and Rhode Island, it's the First Circuit, liberal, headed by one of the liberal or moderate Supreme Court justices. And then on the West Coast, Oregon, Washington, California, the Ninth Circuit, Ninth and First, and then DC, the DC Circuit. So these are the circuits you want to be in if you're a moderate, fair-thinking, free-thinking person. as opposed to the Texas two-step that Donald Trump has always used during the Biden administration to oppose all of Biden's policies, where he finds a MAGA right-wing Texas judge in one, single judge in one district like Kaczmarek or Reed O'Connor, and then boom, he takes it to the Fifth Circuit. He gets, he pulls a panel that includes, Andrew Oldham or Judge Ho or somebody else. They're all trying out for the Supreme Court. Pick me, Donald. And then they rule against the Biden program or that program. And then you got to go to the Supreme Court through a justice like Clarence Thomas or Alito. That's what happens in that scenario. We have our own version of that, and you're watching it here. So far, he's 0 for 3, Trump. I expect there's going to be another temporary restraining order entered in the birthright citizenship case, because that was filed in 3 different jurisdictions in total. And we'll continue to follow it all right here. What does it mean? It means I think everybody waits, including on the Trump administration side, the Department of Justice and all. I think they wait until the preliminary injunction hearings in all of these cases, which should be over the next week or so. Then the loser of that is not going to wait around for the full trial. I believe they'll try to take emergency applications to the appellate courts, the 1st and the 9th, favorable again to democracy. Those courts will probably, I believe, rule in favor of the judge's ruling and against the Trump administration. They can then take an emergency application to the United States Supreme Court, but they generally have to go through these moderate judges that sit over the 1st and the 9th. And then somewhere in the next 2 months, we're going to see the birthright citizenship case and the case about blocking the freezing of the funding all end up at the United States Supreme Court in the second half of its term. And they stop hearing cases in April unless it's on emergency application. Little confusing, but I continue to map it out for you. I'll quarterback it out for you. I'll use a whiteboard for you, at least visually, mentally, orally, whatever the word I'm looking for. It's late at night, I'm sorry. Here on Legal AF. Take a moment, help us grow this channel. We're so close. We're going to hit 450,000 subscribers, all free this weekend, I assure you, with your help. Right? I can only vote once, and I already voted. Hit the free subscribe button. And then at the rate we're going, by mid-February, we're going to hit 500,000, which is going to be before our 5-month birthday, all because of you. Really appreciate your help here. I'm Michael Popak on All Things Legal AF. Again, reporting. Catch us on Legal AF, the podcast, Wednesday and Saturday nights at 8 p.m. Eastern Time on the Midas Touch Network, and then on audio podcast platforms of your choice. And one last place, Popak Live, Tuesday nights, Midas Touch Network, 8 p.m. Eastern Time. It's just me. It's 45 minutes to an hour. It's every topic I can think of that I think is important that you need to know about. I take questions, I give answers, I don't pull punches, and I don't blow smoke or sunshine. I'm Michael Popak. You're on Legal AF. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories, the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.